Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Razam Pereira. Well, the Pinarayi Vijayan-led LDF government in Kerala on Tuesday moved the Supreme Court against the Citizenship Amendment Act, a first by any state government. They sought that the act be declared as violative of the basic structure, principle of equality, freedom and secularism. The Kerala Assembly was also the first in the country to pass a resolution against the act. The CAA grants Indian citizenship to non-Muslim minorities who migrated to India from Afghanistan, Pakistan and Bangladesh following persecution over their faith. Now, the Kerala government has said in its suit that there is no rationale in grouping together the three countries for the purpose of the CAA. In its suit, the state referred to Article 131 of the Constitution. On this edition of The Big Picture, we will take a closer look at Article 131 and special powers of the Supreme Court. Joining me on the program today are P.K. Malhotra, former Secretary, Ministry of Law and Justice, Government of India; Satya Prakash, legal editor of the Tribune; and Aishwarya Bhati, advocate of the Supreme Court. Thank you to all my guests for joining me on this edition of The Big Picture. Aishwarya Bhati, let me begin the program with you. First, let's try and put into perspective and understand what Article 131 is that the Kerala government has decided to invoke to challenge the constitutionality of the CAA.
So, Article 131 is the original jurisdiction of the Supreme Court. It provides that if there is any dispute between one or more states on one side, one or more states on another side, or there is a dispute between states on one side, one or more states on one side, or union on one side, with regard to any law point, any question of fact which turns on a legal issue, then they can come directly to the Supreme Court. Otherwise, all other suits, High Court is the petition for, or the first the courts of instance are the courts for suits to be filed. It's only between the states and union that this is available. But I should also add that this, this does not deal with, actually there is part 11 of the Constitution which deals with the division of legislative work between the union and the states, and it is very clearly defined in 7th schedule of the Constitution as to what will be the list under which the union can make a law, the parliament can make a law, which is the list under which, what are the subject matters on which the state can make a law, and the concurrent. Now, in the union list, citizenship is there, that union is empowered to make a law. So, the best of my understanding as a student of law, I think it is a misconceived petition. Okay, all right.
Satya Prakash, are there any conditions, any criterion for a state to file an original suit in the Supreme Court?
No, as Aishwarya has already pointed out, it's just the question of fact or question of law. If there are any, then and between two estates, two or more estates, or estates on the one side, or one estate on one side, center on the other, then it can be filed. And Supreme Court has original jurisdiction in these matters. In fact, Supreme Court has basically three kinds of jurisdiction. One is original jurisdiction, 131, then 131 plus advisory jurisdiction under 143, and then this is appellate jurisdiction. There are appellate jurisdiction in civil and criminal matters. Apart from that, they also have contempt jurisdiction. But here, the real question is not whether a state government can file a petition in the Supreme Court relating to such issues. The real question is whether they can challenge a law enacted by Parliament under Article 131. That's the real question. In fact, I can recollect in 2017, the West Bengal government had filed a petition in the Supreme Court challenging the validity of Aadhaar Act, and they had invoked Article 32. And the Supreme Court asked that, does a state government have fundamental rights? Because Article 32 is available only for enforcement of fundamental rights, and then only you can directly approach the Supreme Court for that. And then the Supreme Court went on to say, if at all the West Bengal government is interested, then Mamata Banerjee, the Chief Minister, should herself file a petition in her personal capacity. But here the states, they have taken, states I am using because it's not just Kerala. Today Chhattisgarh government has also filed a petition challenging
different issue, NIA.
Yeah, validity of NIA Act. Incidentally, the Act was enacted in 2008 when the Congress party was in power. Today in Chhattisgarh, Congress party is in power, and I find it completely a political issue, because they are trying to say that laws enacted by Parliament are not applicable to states. There are some nuanced stance they have taken, but that is regarding certain entries in the state list. But so far as Kerala government is concerned, what they have said is that under Article 256, the state government is bound to implement laws enacted by Parliament, and what further they said was that since the law is manifestly arbitrary and unconstitutional, so we find it difficult to, we are not in a position to implement it, and it violates fundamental rights of citizens, blah blah blah. To my understanding, it is not open to states to say that we will not implement the law because it is manifestly arbitrary or unconstitutional, because the constitutionality of a law or otherwise is to be determined by constitutional courts, be it high courts or the Supreme Court, and there are already 60 or more petitions pending in the Supreme Court, and the Supreme Court will take them up. The question is, there is a validity, the presumption of validity in favor of laws enacted by Parliament. Unless and until laws enacted by Parliament have been declared unconstitutional, the states are bound to implement. The Chhattisgarh instance or this instance, both in a way, it's a misconceived notions of federalism.
Okay.
Where the states are trying to somehow, trying to poke their nose into certain areas which are somehow reserved for the center. Here, naturalization and citizenship both are under entry 17 of list 1 of the 7th schedule. So it's a thoroughly, there is no question of legislative incompetence. Parliament is thoroughly competent to enact laws on lists on issues enumerated in list 1 of 7th schedule, and this is under entry 17. In case of Chhattisgarh also, they are saying that because there are certain when NIA acts, they are going into territory of Chhattisgarh, or territorial issues they have raised. It is not about geographical territory, it is about the lists, the subjects which are enumerated in these 3 lists.
Okay.
And I don't know how whether the viewers know it or not, the Union Parliament, it has so much power, not just entry 1, entry 3 also, concurrent list, laws made by Parliament shall override the laws made by the states. Even in entry 2, that is state list, the Parliament can make laws in certain circumstances. When there is president rule, all the legislative powers of the state assemblies are transferred to the Union, that is Parliament. There are certain other circumstances where, supposing Rajya Sabha has passed a resolution by 2/3 majority, in that case, even that case, the Parliament can make laws on subjects enumerated in the state list. And further, if 2 or more states together they pass a resolution, state assemblies, and request the Parliament to make laws, even in that circumstance, Parliament can make laws. Here, unnecessarily, there are certain issues which are political in nature. They should be fighting these issues on political planks, trying to disturb the constitutional balance, taking this kind of stance. It will disturb the federal structure, which the states have been, time and again saying that India is a federal state, and center should be respecting the powers of the state. Here, I find a very interesting thing.
Okay.
As if federalism is just one-way street, where the center has all the obligations, the states have none.
Okay, all right. Points taken. Mr. Malhotra, how would you read these 2 instances, both the instances raised by Mr. Satya Prakash, Chhattisgarh and Kerala as well, 2 different issues?
Mr. Frank, I think the issue for discussion today is what Article 131 says, more particularly with reference to the petition which has been filed by the Kerala government in the Supreme Court under 131, challenging a central enactment, that is the Citizenship Amendment Act. So first, let me talk about Article 131. My understanding is Article 131 is a special jurisdiction of the Supreme Court to entertain a civil dispute between on fulfillment of certain conditions. What are those conditions? Number 1, the provision of Article 131 are subject to other provision of the Constitution. In case there is other remedy provided in the Constitution itself, then probably 131 will not be available. Take for example, if there is a water dispute between two states, there is a separate article, Article 262 dealing with it. Parliament can make a law on that. So that dispute cannot come in 131. So this is subject to provision of other constitution. What are the other conditionalities to be fulfilled under Article 131? The dispute must be between states, two states, or between state and central government, or between central government, state and other states, or between states and central government. So there has to be, it cannot be a state entity. It has to be a state government and the central government. That is one condition. And the most important condition is that it with the dispute must relate to a question of fact or of law relating to legal rights of the parties. Now the question which has now the court will have to decide in this particular case, because what the Kerala government has challenged is the law passed by the parliament. It is not a case that for the first time the state government has filed a civil suit under Article 131 challenging this central law. There have been instances in the past also. For example, West Bengal has challenged a central law with regard to rights in mines.
Coal area.
And probably coal area, and the Supreme Court entered in that under 131, and Supreme Court said that under 131 such a petition can be filed, but the law passed by the parliament was upheld in that case. The question here will be, the petition which has been filed in this particular case, whether it really affects the legal right of the state. What legal right of the state is. Now I am trying to distinguish between the two cases with regard to coal mine earlier. There of course the state has legal right. Here what the Kerala government is alleging is violation of fundamental right. Now government itself is a state entity. If for violation of fundamental right any petition is to be filed, the right remedy is available either to a person or to a citizen under Article 226 or Article 32. Can state say that its legal right has been violated because some fundamental right of some citizen, even if it has been violated, does it give a right to the state? I think the Supreme Court will have to decide this. There have been instances in the past where there has been petitions filed under 131 by state of Karnataka, by state of Bihar, by state of West Bengal on various issues, and in each case the Supreme Court has decided whether any right of the state government, any legal right of the state government, mind it has to be a legal right, not a political right. If suppose the government at the center on political issues also passes a law in exercise of its power given to it under the Constitution, does it really violate the legal right of the state? I think that is the issue which the court will have to decide. And as my learned two co-panelists have said, prima facie it looks, probably what the state government is trying to say is that their fundamental right has been violated, which probably apparently doesn't seem to be correct, but since the matter is now before the Supreme Court, whatever arguments come before the Supreme Court will take a call on that and a decision will be.
Okay, Aishwarya Bhati, this brings me to my next question now. Can the Supreme Court test the validity of law under Article 131?
Well, let me break it down a little. Under the Indian constitutional scheme, the only way that the legality of a law can be challenged is only if the law is contrary to, it violates or contravenes in any way Part 3 of the Constitution. Now, Part 3 of the Constitution is that part of the Constitution which contains fundamental rights. It enumerates all the fundamental rights. So, only way that a law can ever be challenged as unconstitutional is only if it is in violation of Part 3 of the Constitution. Now, Part 3 fundamental rights, like Sir Malhotra sir has rightly put, fundamental rights are rights which are available to citizens and non-citizens. There are a lot of fundamental rights which are available to non-citizens also, but available to citizens and non-citizens persons against the state. These are not rights which are available to state. So once there is no right, fundamental right available to the state, then there is no question of any violation of any fundamental right of the state, and therefore, in my opinion, there is really no remedy available to the state at all to challenge a law as being unconstitutional. It could be challenged as, in excess of the legislative power of the union or state, which essentially comes from Part 11 of the Constitution, which talks about these three lists which Satya Prakash ji has spoken at length about. So entry 17 of list 1, which is the union list, speaks about citizenship. This law has been passed under that. So really the state can only challenge a law as being incompetent. Parliament is incompetent to make it. That the Kerala is agreeing in its petition that this petition is in terms of the competence. They are claiming violation of part 3 of the constitution, which is not available to any state. In fact, there are other petitions that are filed. Those petitions are filed by persons, citizens, non-citizens, etc. In that, the Supreme Court will examine the legality of this act. It's not like they won't examine. But this, again, because the no remedy is really available to the state, this is nothing but political posturing. In fact, some of the states have gone ahead and said that they are not going to follow this. Under the Indian constitutional scheme, there is no latitude, no liberty whatsoever to any state to say that they will not follow a law that is passed by the parliament, because any law that is passed by the parliament, once it is in terms of the union list or the concurrent list or special circumstances, it is constitutional, it is legal till the time it is declared unconstitutional by the court for in any of the petitions.
Okay, all right, Satya Prakash, since you are here now, so what happens in a case where the states decide not to adhere to the law?
Well, I don't think the states are saying we will not adhere. Kerala Assembly has passed a resolution, but here in this petition they filed in the Supreme Court, they are saying under Article 256 we are bound to implement, and we find that it is manifestly arbitrary and unconstitutional, hence kindly declared it so, because we don't want to implement. So they are saying they are bound, they are accepting the constitutional position under Article 256. But whether the law is unconstitutional or not, or on what grounds it can be declared unconstitutional, basically there are 3 grounds. One is legislative competence, whether Parliament is competent to enact a law on the subject. Basically you check the list, whether it is in 7th schedule, whether it is part of list 1 or list 3, or in special circumstances it can be even in list 2. The second is whether it violates fundamental rights or not. In some cases, it can be even violation of constitutional rights, which can be a ground for declaring a particular law unconstitutional. And finally, the basic structure test laid down by the Supreme Court in Case 1 and Bharti case in 1973. That is the ultimate test for any law to pass to become constitutional. But these 3 are a very distant issue. In fact, Mr. Malhotra has nailed it in the sense that unless the states prove that their legal rights are somehow affected by the law in question, there is no question of Supreme Court entertaining it. And Mr. Malhotra talked about the law, the Supreme Court verdict in West Bengal's case in 1960s. In that case, neither the maintainability of the petition was questioned, nor the issue of fundamental rights was raised. Here, they are raising the fundamental rights issue, and Centre, I am sure, is likely to raise the issue of maintainability. At least one such issue, in case of Madhya Pradesh government, I think they had challenged certain aspects of Madhya Pradesh Reorganization Act regarding electricity or something. That was referred to a larger bench, and that is still pending before the larger bench. So this issue, which if at all the Supreme Court entertains it, it will be most likely referred to a larger bench, which is already there in case of Madhya Pradesh. And then maybe from larger bench it goes to a constitution bench. But this issue has to be settled for all times to come, because this kind of tendency in a federal structure, because it has the effect of crippling the functioning of the entire structure. Because the states, they have been cribbing about the center, trying to interfere in their spheres. Here is the case where the states are trying to take undue advantage of political environment, and they are agitating issues which they must not.
Okay, so Mr. Malhotra, so at least 4 occasions where I can count where the states have used this particular route, the original suit route, to go to the Supreme Court and to deal with issues like this. What have we learnt over the years as far as Article 131 is concerned?
You see, I think Article 133 was a necessity, and it must be there because in a federal structure, in
131
case
or 133?
130. Under Article 133, I think it was a necessity because in a federal structure there is division of power between the central government, parliament and the state legislature. And in case there is a division, the possibility of some dispute arising either on fact or on law cannot be ruled out. Therefore, the constitution framers were wise enough to put it specifically in 131 that in case there is any dispute arises between the states, then obviously the Supreme Court being the apex court, because if there is a dispute between two states, obviously you can't go to one of the high courts because there is a possibility of saying that the court may not be impartial. So therefore it has to be the apex court of the country. Therefore the apex court will decide this kind of disputes. And my understanding is that even after the dispute, whatever the court says, it becomes binding because it is the apex court has decided it. More or less it is declaratory in nature, but it is binding on the parties. Second thing which I want to highlight here is because I am talking of the legal rights here. And Mr. Satya has very rightly pointed it out, and I would like to take it further. The resolution passed by the Kerala Assembly, it nowhere says that we will not implement the law passed under the Citizenship Amendment Act. What they have said is that the Parliament should reconsider it because the House feels that probably it is in violation of the provision of the Constitution. Since they feel that therefore it should be reconsidered, they have not said that we will not implement it. If they say we will not implement it, probably the consequences will be entirely different. Then as pointed out by my co-panelist also, under Article 256, which has been mentioned by the Kerala government itself, probably an advisory or a direction can be issued by the central government to the state to implement it. And in case the state doesn't implement it, then the natural consequences under the constitution will follow, and probably center can take a call that the government of this state cannot be run as per provision of the constitution, and natural consequences will follow. But anyhow, we are not concerned with that as on today because that's a different issue. Now talking of this particular aspect of power under 131, as I said, according to me, more or less whatever decision is given, this is with regard to a dispute which is arisen, and dispute must relate to a legal right. Now the court in this particular case will, and obviously I am sure central government will argue on the ground of mental ability, as Satyaji has very rightly pointed out. And after that, what legal right of the state in this particular case in passing this law by the Parliament of the Kerala government has been violated will also have to be decided. In case it is there, then obviously the dispute will be adjudicated by the Supreme Court. In case no legal right is violated, then if it is a political decision, obviously the Supreme Court will not intervene in such a matter.
Okay, all right. Time now to get closing comments from all my guests with the best way forward, starting first with you, Aishwarya Bhati.
Well, we've seen recently, I mean, this was a trend that happened even with the Motor Vehicle Accident Amendment Act. The government took the opinion of the Attorney General for India, and because some of the states there also were saying we are not going to implement it. Here also Kerala has filed a petition, but there are other states who have been saying we are not going to implement it. That is not available. That's liberty and latitude is not available. In fact, the Attorney General's opinion went on to say that if the states refuse to apply a law that has been passed by the Parliament, it actually amounts to breakdown of the constitutional machinery. The problem, I think, is that these political parties from the states, their representatives who are there in the Parliament, they don't make a point when they have to make a point, and then they use the courts of the country to make their political posturing. I think the Indian Supreme Court is going to see through it, and the petition will be dismissed as non-maintainable because this just can't go on. It is completely contrary to the federal structure, and it is completely the petition itself is unconstitutional.
Okay, all right. Satya Prakash?
Well, I agree with what co-panelists have said regarding CA, but regarding NIA, there is a report of the Niti Aayog in 2017 in which Niti Aayog suggested that there should be a list of federal crimes which should be created, and the list of federal crimes should be investigated only by the NIA or the CBI. It is high time that report is implemented, and Parliament should take a call on this because that will eliminate the confusion which is regarding NIA. Right. Because in case of Chhattisgarh, at least they can say that there are the issue of police and public order is in a state list. So there is some sort of overlap, or at least they can take that benefit of that confusion. If the federal crimes are created, a list of federal, that will eliminate the confusion for all times to come.
Okay, all right. And Mr. Malhotra, close the show for us.
Aishwarya has drawn a comparison with the Motor Vehicle Act, and I think that's a very good example for the purpose of understanding of our viewers. You see, Motor Vehicle Act falls under list 3 of Schedule 7, where probably if the state want, the Legislative Assembly can pass a different law, and in case it gets the assent of the President, it can be implemented in a modified form. But so far as the subject matter of list 1 is concerned, that power is not available to the state government. Therefore, it is the bounden duty of all organs of the state, be it legislature, be it executive, be it judiciary, more particularly the legislative and the executive, because state legislature and central legislature are different. State executive and the central legislature, they must respect the Lakshman Rekha which has been drawn by the constitution for performing their duties. And in case one or all of the government has passed a law, the other organ of the government must respect it.
Okay, all right. On that note, then we'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. That's it from me. See you again next time.